And I know this seems like a silly topic to discuss after we discuss things that are really, really important. But obviously, we all know what happened last month with different folks approaching us wanting to come and bring the invocation. And so I asked Donna for some legal guidance on this based upon the Greece versus Galloway decision and another decision that was in reference to Nebraska, state of Nebraska. And she put this together. I know I want her to speak to it, then I want to address it as well.
Please note that I invoked the attorney-client work product privilege under Chapter 119. It's 119.071D, in that the information I've given you reflects my little processes of legal theory. First of all, Galloway was released May of this year, so it's only 4 months old. As I was doing this memorandum, yesterday I got the technical guidance I was hoping for from the Council of School Attorneys. I've gone to several sources to try to get what different viewpoints are saying about the Galloway decision. We've been referred to the Freedom from Religion Foundation by some constituents. Their page titled Prayer at Government Meetings says this page is being edited to reflect the Town of Greece versus Galloway decision. So I got no guidance from that. It's fair to say that this case is 4 months old. The interpretation of it is very much in flux. It is not static. It's not like Brown versus Board of Education that happened in 1954, and we know more or less what it means. This is an incredibly meaty decision. I could argue several different things that it's going to end up meaning to us. At present, I do not see that the board has to change its past practice. I will warn that past practice does carry some degree of risk of litigation. The only way to be sure you will avoid litigation is to go to something like a moment of silence or to do away with the invocation. Although, arguably, if you do away with the invocation, as I noted in my information I gave you, there's an argument that violates the Establishment Clause. The problem is you've got two constitutional clauses, the Establishment Clause and the Free Exercise Clause, that really can't live well together. And so that comes very much to the forefront in trying to figure out what the Galloway decision means. So at present, nothing's necessary, but you may face litigation. If you want to avoid all chance of litigation, there are some ways you could go. I don't make policy, so I've basically told you what your options are, and it's up to somebody to decide to make a recommendation.
Well, Mrs. Waters, thank you very much for taking the time to put that together. And I read it, and I appreciate it. You've listed some options that you think are good, but I guess the important thing is the reason I put this on the agenda. This is the meeting where we can discuss it as a board, and that's important because I need to know where everyone else is on this. I'm willing to be open-minded, and as a matter of fact, I've been in contact with a person of a religious belief other than Christian. And next time around, when it's my turn, I'm going to bring this gentleman in to bring a prayer. He's a person of the Jewish faith. So, in hearing what you said, as long as we don't stick exclusively with the majority religion, it's your thought that we are within. Is that?
I'm not sure about that. What I will say is the holding of Galloway was that a legislative body does not violate the First Amendment by opening its meeting with prayer. We keep using the word invocation. As I told y'all, invocation and prayer can be two different things. The Galloway decision specifically addresses prayer. It has to comport with the historical tradition of legislative prayer, and that gets into who is the audience for the prayer.
Well,
and then it can't coerce participation. as we've seen people feel free not to participate, we do offer public forum to anyone who wants to make a different viewpoint. So,
Well, thank you, and I definitely want to hear from my
What
counterparts.
is the definition of invocation as it is related to this? She said there's
Okay.
invocation are different.
the courts have not discussed the difference between invocation and prayer, although the Galloway decision discusses prayer. But in general, when you're looking at something, even when lawyers look at it, if there's not a court-adopted definition, then you're supposed to look at the general understanding of the word. The general understanding, I went for invocation, I went to several dictionaries, I've done the same for prayer. An invocation is the act or process of petitioning for help or support. It can be a prayer of entreaty or a calling upon for authority or justification. So one can call upon, the history of the U.S. for justification. One can call upon something that is not a deity and say, this is what I'm calling on as my authorization or authority for what we're doing here. Prayer, however, consistently amongst the dictionaries I went to, is defined as an address to God or a god, or gods. Therefore, it seems to be embracing a theist worldview. I don't know how far y'all want me to go with that. I can argue a whole lot more about what it does and doesn't mean. There are, in fact, the town of Greece, where all this began, the town of Greece has now adopted a practice where they have a leader of a religious body invited to give a prayer at the beginning of each board meeting, basing that on the idea that what they litigated about was prayer.
Okay, any comments? Mr. Radash wants to have a discussion.
You guys okay with keeping it the way it is?
Ms. Hightower?
Yes, I'm okay with keeping it the way it is. I talked to Ms. Waters because the bottom line for me is what we're doing going to land us in court. I don't want to spend time and money litigating something when we have much larger issues. When I invite someone to come to start our meeting, I always give them some guidelines, and I always say that whatever you say cannot be offensive to anyone else. And I have been blessed to have a lot of people who come and they understand what I mean by that. And since we've got the gentleman in the room, I was a board member who responded to him that I would put him on my list. And now, he is no longer on my list.
Okay,
And I'll talk with you afterwards why.
Mr. Boone?
I'm certainly in favor of keeping the procedure the way we've been doing it since I've been on board.
Mr. Slade? Okay, and I too am okay with what we're doing now, and unless we're made to do something differently.
I appreciate that, you guys. I just wanted to have a talk with you on it. Thank you.
All right, Mr.